back, everybody, to the Law&Crime Trial Network. I'm your host this afternoon, Rachel Stockman, and I will be guiding you through our trial coverage this afternoon. We're going to turn now to California, where we've been covering this fascinating case. It started with the disappearance of a family, and then police said it was something much more than that. Take a look at this review of the McStay family murders case.
Merritt is facing murder charges for allegedly killing a family of 4 and burying their bodies in the desert. Joseph, Summer, Gianni, and Joseph McStay Jr. vanished from their Southern California home on February 4, 2010. Police found no evidence of struggle or foul play, but did identify signs that the family left in a hurry. The family car was found 4 days later abandoned at the Mexican border with no sign of the McStays. Law enforcement eventually believed the family fled to Mexico. Surveillance video at the border showed a family of 4 resembling the McStays crossing the border on foot. Officers also found search history on the family computer about travel to Mexico and passports for children. But a grisly discovery came nearly 4 years later when an off-road motorcyclist discovered the partial remains of a child's skull on the outskirts of the Mojave Desert. A search revealed 2 shallow graves containing the remains of 3 more bodies. DNA and dental records matched the bodies to that of the McStay family. A 3-pound sledgehammer was buried with the bodies. The family had been bludgeoned to death, according to prosecutors. As law enforcement was investigating the McStay's family disappearance, San Diego detectives interviewed Charles Merritt, a business partner of Joseph McStay. According to the affidavit, it was determined that Merritt was the last person to see and talk to Joseph alive. The two had met at a fast food restaurant before the family went missing. The last cell phone activity on Joseph's phone was a call to Charles Merritt. Merritt's DNA was also found on the family car abandoned at the border on the steering wheel, the gear shift, and the radio. He claimed he never driven the car, but rode in the passenger seat with Joseph 6 weeks prior to when the family went missing. Charles Merritt is pleading not guilty to the charges. Defense attorneys are pointing to another business associate as a possible suspect. Merritt is facing 4 counts of murder. For Law and Crime, I'm Rachel Stockman.
And we've been following that testimony very closely in the McStay family murders trial out of California. Court is on break for the day. They will be back, though, on Monday, and we will resume our live trial coverage then. But for now, I want us to begin our review of all of the evidence surrounding this discovery of those bodies. Let's listen now to the person who actually found that skull near the desert. Take a listen.
Back on November 11th, 2013, did you happen to be in that area?
Yes, I was.
Dare I ask what you were doing?
You can ask. I was writing. It was a holiday.
Okay. You remember what holiday?
Veterans.
Okay. And what were you writing?
Motorcycle, Kawasaki, KLX 650.
Just out for a pleasure ride on the long weekend?
Yeah, yes, just getting exercise and checking around.
Okay. Were you alone or with others?
Alone.
At some point, did you find something that you found interesting?
Yes.
Can you tell us how that happened, please?
I was traveling on a dirt road and glancing off the road to my right, which would be north, looking for trails. And I thought I passed the trail, but I wasn't sure, so I kind of went up a ways, went off the road, and circled back towards that, to angle towards it. Well, I didn't find it, the trail that is. On the way back to the dirt road, I stumbled across the remain.
Okay, so you saw something that attracted your attention?
Yes.
At the time, did you know what it was?
A bone.
Okay. Did you know what kind of bone?
No, not for sure.
Okay. What was it about? What about it attracted your attention to make you stop and go, "Hey, what's that?"
It just looked out of place. It was a loose white bone It was round. It looked like a tortoise or something like that.
So you mentioned at the time that you didn't know exactly what it was. What did you do?
I stopped and I put my bike on the side stand. I walked back and I looked at it and I thought that might have been a human.
So what did you do?
I went back to where my bike was, which was on a little hill, and I called the sheriff's, or I called 911.
Why'd you call 911?
Well, in case there was somebody, in case there was a baby or something like that, I thought you better know about it.
This morning, did you have an opportunity to listen to your 911 call?
Yes, I did.
Okay, so the man you were just listening to is describing finding that skull. You saw a picture of the skull that they were showing to the jurors in evidence. But I just want to give you a little bit of context in terms of a timeline. Of course, the family disappeared in 2012. In April 9th, 2013, authorities observed what they thought was the family crossing the border into Mexico. And at that time, police declared the family had left voluntarily. They did not think foul play was involved. And then months later, November 11th, 2013, that is when that man made the discovery near the Mojave Desert. And that's when this story totally changed. He called 911. Take a listen to what he said.
Hi, I'm out here on a motorcycle up behind the dump, and I found what looks like a human skull.
Can you give me a location?
Yes. Okay. West of the 15 and north of the stockpile where the dump is. Maybe I should just call the local sheriff and tell them where it's on a map, because it's all dirt roads.
I understand, but I'm just looking for a starting point. And this is the local sheriff.
Oh, okay. Starting point. Start at the 15 north Starting Road exit.
Okay. Let's see, is it over by the landfill?
Yes. It's within, I'd say, about a half mile of that landfill. It's directly to the south of me.
Okay, so from the landfill, where are you?
Due north, approximately, I'd say a good 2,000 feet.
Okay. Did you find it in the landfill or just in a field out there near it?
In a field.
Okay.
So John Bluth's discovery in the desert there was a huge break in this case, because all of a sudden it transformed from a missing person case where the family was presumed to have left the country voluntarily to something much darker and something much more complicated. I want to bring in now my guest, LaDawn Jones. She joins us via Skype, a criminal defense attorney. Let's talk briefly about the discovery of these bones.
Absolutely. You know, when you have a witness like this, that is a neutral witness, has nothing to, any reason to have bias in the case, these are the kind of witnesses that win a jury over. It's also the kind of witness that you can use to establish that the state has a whole lot of evidence to present, because you're able to talk about where and when and put in timelines. It's scientific stuff, not this witness, but it leads to some scientific evidence that helps to really draw a case in. And I love witnesses like this because they're just telling the truth.
And LaDawn, as we kind of talk about the length of this trial, it's already, going on now. I believe we're on the 13th day, was yesterday, and it's going to go into day 14 on Monday. How do you think the defense is going to have to tackle what could be a months-long case where the prosecution has had all of this time to build their case?
You know, you have to have one or two really basic strategies. Either the defense has a whole lot of evidence to present on the side, which is very rare. They're not presenting a lot of their own witnesses, right, to counterbalance or to lead to that reasonable doubt. or you poke holes in every witness that the state presents. Anytime, for every jury, they'll tell you that when you hear the state's case, it seems impenetrable until defense has an opportunity to truly get up and put up their own witnesses. With a long trial like this, juries get tired, and so probably going with the initial strategy of poking holes in the state's case is going to be how you best manage it.
And they certainly are trying to do that, also pointing the finger at another man for the person who did this to the family. Okay, we are going to take a quick break here on the Law and Crime Network, but when we return, we're going to delve into some of those gruesome details of what was found in that shallow grave near the desert. Stay with us here on Law and Crime. Again, investigator going through what was found in that shallow grave where 3 years after the family had disappeared from their California home, the remains of their bodies were found. Let's continue to listen to this important testimony.
So up here would be the victim's head. The hole that I described would be right here where there was obviously wounds to his head. You can see here his back continues down. These are the victim's ribs. As we continued uncovering it, we located a white extension cord that was wrapped around the victim's neck that continued south through the grave. The way that the victim's laid out in the grave, his legs continue down here. So at this stage, you can see part of the bottom of the victim's legs here, but there were no skeletal remains located below the kneecaps inside the grave, or below the knees there.
As the excavation continued, please describe what you were seeing.
So as it continued, like I said, we located the white extension cord. The extension cord was found to be tied in a knot around the victim's neck, and it continued south through the grave. It was found that the victim was wrapped in the white blanket that we initially saw, what we believe to be a white blanket, a white woven cloth of some sort, and the cloth was wrapped with a red tie-down, like a tie-down type strap.
Okay, so I want to talk for a minute about what that detective said they found in the shallow grave. They said they found the victim, Joseph McStay, wrapped with an extension cord around his neck, also commenting to the fact that they found no remains below his knee. Let's bring in LaDawn Jones. What does that tell you? I mean, this is just such a brutal murder, but that was done particularly to Joseph McStay. Does it give you any kind of indication of what was in the perpetrator's mind?
Well, there's a few things that stand out to me, and I love when detectives are able to testify from the stand because they'll explain things to you like the fact that the rope was still there or whatever was used for strangulation still being there is an indication that, you know, he was buried very quickly on the spot where he was, where he died. The fact that his portions of his body are missing are other signs that there was some severe abuse or something related to how he was murdered. And so this was anger. This was personal. This was not something that was
personal. And there you can see the extension cord. I'm sorry it's a little brutal, a little hard to tell, but does it seem like to you, here's something that always gets me caught up with this case. Based on what you're hearing, and we're going to go into more testimony from this detective about what was discovered in the shallow grave, does it seem like one person could handle doing what was done to this family by themselves?
You know, it really would depend on the circumstances. You know, this type of murder, this type of brutal murder indicates somebody who definitely has evil intent. And a certain amount of evil intent, there are so many possibilities that are available for a very scared family. But it would not be unlikely that the defense's theory, another dude did it, or that there's reasonable suspicion that the facts as presented by the government doesn't add up. This is a good argument to make because it is a family of four.
All right, let's continue to listen to Detective Edward Bachman describing really some of the disturbing things that were found in the grave.
So you mentioned at the time that you didn't know exactly what it was. What did you do?
I stopped and I put my bike on the side stand. I walked back. and I looked at it, and I thought that might have been a human.
So what did you do?
I went back to where my bike was, which was on a little hill, and I called the sheriff's, or I called 911.
Why did you call 911?
Well, in case it was somebody, in case it was a baby or something like that, I thought you better know about it.
This morning, did you have an opportunity to listen to your 911 call?
Yes, I did.
And you know what, LaDawn Jones, I also want to talk to you, because we talked briefly about this. He was referring in that testimony to the 911 call. What did you make of the fact that this guy was so observant to be able to notice what he thought were some remains? It's not clear if he thought right away that they were human remains, but it definitely stuck out to this guy.
Absolutely. And I think that that's what makes him believable, right? Anytime a person were to walk somewhere like the desert and see anything that's like remains, it's going to catch our attention. And then you've already noted many of the different unique characteristics of these particular remains. It makes him a credible witness to all of where it was found. There's no question that maybe he's the killer and that maybe he found it somewhere because he was able to give those details.
Yeah, I mean, just to have this case where, you know, it seemed like it for years that if Charles Merritt is the killer, like the authorities and prosecutors believe, that he probably thought, wow, I may have gotten away with this crime. It's been 3 years. No one's discovered the bodies. The police are confident that this family had escaped to Mexico. Then all of a sudden you have what only can be described as damning evidence that this was a vicious attack on a family.
Absolutely. And then also you would think that it goes back to the viciousness of the attack and the spontaneity potentially of it, because you would think after this much time has gone by, do you go back and look at the remains? Do you try to move them around to further hide your evidence now that you know that they have not been found? It makes it all very interesting and goes to the mind of the alleged murderer.
All right, when we return, we're going to take a quick break, but we're going to talk about Summer McStay, how she was found, what were the circumstances around her killing. Stay with us here on Law and Crime. Okay, let's continue to listen to a bit more of this crime scene specialist testimony. Specifically, she talks about how investigators found Summer McStay's pants and underwear pulled off together. Take a listen.
On this half of the bra.
Yes, I did.
Yeah, can you show it to us and describe what you observed?
When looking at the photograph on the left side of the bra, there appeared to be, I call it a white substance. It to me was consistent with paint, but I don't know for sure. Excuse me, exactly what it was.
It had a distinct pattern to it, correct?
Yes, sort of like a drip. It was dripping.
Can you orient what you're seeing to us on how it would be if worn? Is that possible?
If this bra, this would be the left cut, so it would be the dripping, the drip, the flow stains right here, where it could the substance appeared to have flown or flowed towards the center. If it was being worn at the time, it would have been towards the center of the bra.
You can see some of the strapping.
Yes, and there appeared to be a cut right down the center of the bra.
That appears to be. Is it smooth or is it frayed?
It was frayed, but it appeared to me to be a straight cut, but it looked frayed.
And is this orientation approximately correct if worn, the way you described it?
Okay, so let's bring in LaDawn Jones again, criminal defense attorney, as we look at that image of the cut bra that was discovered. What does that tell you about what happened?
You know, there's a lot that you can presume in this. And as a prosecutor, I will be very cautious here, right? Not to make inferences that you truly can't connect the dots on. You know, it's one thing to say it is potential that she was raped. Or maybe with this violent murder, he was simply trying to humiliate her. Maybe it was a struggle. There's too many what ifs. And if the prosecution goes too far trying to fill those connect the dots with evidence that isn't there, it ultimately weakens their other evidence.
Right, and so far the prosecution has been careful not to outrightly say the rape part. However, in an investigative report filed, one of the investigators believed she had been raped. And in fact, the defense attorney, during the defense's opening statements, even mentioned this fact, referencing, you know, what motive would Charles Merritt have for raping this woman, Summer McStay? If he was really angry at Joseph McStay, why would he rape Summer McStay, kill her, and why would he kill the children? I'm trying to say, you know, this doesn't really line up, even if they had some kind of business dispute.
Absolutely. And I think that the defense attorney handled that well. You know, I would have also thrown in there, however, because, you know, you have to remember a jury are people who've never been to jail. They've never been convicted of a crime. And so when they think of people who are evil, any type of evil excuse would be fine for why would he take a business issue and turn it into a violent murder, including rape. You're already accusing him of something horrendous. So it would have been a better use to be able to say, listen, this is when the cops are looking for our hammer, everything looks like a nail. And they've accused him of potential rape and started investigating something without evidence, just like they did the entire case. And that may have made the jury be a little bit more suspect of anything that the state presented.
And one of the pieces that they did find with Summer McStay was a sledgehammer, which investigators believe was used to bludgeon this family to death. So really what I'm garnering, what I'm getting from the introduction of all of this evidence of what was found in the gravesite was just how brutal this crime was to this poor family. Okay, let's listen to more of the testimony. Oh, you know what? We're going to take a quick break, but when we return, we'll listen to a bit more of the testimony from what was discovered in that shallow grave. Stay with us here on LaDawn. And breaking news, everybody, in the investigation that Robert Mueller is conducting against Trump and his associates. Roger Stone, as we reported earlier, was arrested on 7 counts, including lying to investigators. Just moments ago, he made several public appearances, including on CNN, saying that he believed the prosecution was politically motivated and that he did not work in any way with the Russians and that the raid terrorized his wife and dogs, but the FBI was courteous. He also said he is not guilty to what he is accused of, and he also made another appearance on conspiracy theorist Alex Jones' website, Infowars.com, saying that he had a First Amendment right to do things for the campaign, and the government is infringing on it, and he was also pressing for donations to his legal defense fund. LaDawn Jones, what do you make of his comments to the media upon his arrest?
You know, one thing that is in common with many in the Trump administration is their inability not to speak. And so Roger Stone, in good form, has continued with that pattern. It is clear that there was some type of involvement. We already know, and we know he's intelligent enough to know that First Amendment does not protect illegal speech to foreign agents. And so he's telling on himself little by little, and I'm excited to see what comes out next.
Yeah, it certainly will be an interesting case, especially when you have a colorful figure like Roger Stone now facing the 7 counts, being arrested in a raid this morning. We talked about that earlier with the folks from Mediaite, how they busted into his house and arrested him around 6 o'clock in the morning. But, you know, a lot of the Trump supporters are outraged how Roger Stone was arrested. But we checked in with some federal defense attorneys and former federal prosecutors, and they say, yeah, you know, it was a bit unusual that this happened at 6 in the morning, that there was such a large police presence. However, it's not totally uncommon when you're arresting someone in a case like this. Do you have any comment on that, LaDawn?
Absolutely. I do federal defense work, and it is very common. Listen, the reality is most people who are caught with crimes like these are arrested on the spot. They don't get a special pickup visit and escort to the jail. And so considering the high media interest in this, the fact that media was already coincidentally out front of the home, it's not surprising that they brought more agents, not only for Roger Stone himself, but to make sure that the entire scene was protected when they did make this very important high-profile arrest.
Right. And, you know, the truth of the matter is Roger Stone has demonstrated himself to be a rather unpredictable character, just based on how he's acted in the media, how he's acted on social media, that, you know, for officers and the FBI to want to take some extra precautions to ensure this arrest happened without any kind of problem is probably not entirely unusual. But he certainly, like Paul Manafort did when he was raided by the FBI during the summer, make a big deal about this, saying that they're going too far and that this is a white-collar crime, and why should he be treated like a hardened, violent criminal?
Right, and we see now that Michael Cohen is singing a completely different tune than he was when he was first arrested. And then we also don't want to undermine the seriousness of these charges. Yes, these are white-collar offenses based on communication. However, the people who they are accused of doing the offense with, Russia, is known for some very violent acts. It's the reason why this is such a big deal, and we should not undermine that simply because of the nature of the original charges. We have to look at the totality of the circumstances and who they're in bed with for very serious crimes against our country.
All right, again, just to recap there, after his arrest, Roger Stone, he appeared in court to face that 7-count federal indictment, now speaking out, saying that he is not guilty and following along the Trump theme of saying that this is a witch hunt against him. We're going to continue to very closely monitor this case. If we get any new information, we'll bring it to you on the Law&Crime Network. Let's turn back now. Bit of a change of gears, back to the McStay family murders case out in California. I want to take you to the home where the family lived, where police investigators believe the crime occurred. Let's listen to a investigator who went to the home.
So now my question is, what were you looking for?
Okay. I'm looking for, primarily under the search warrant, evidence of a crime. I'm not looking for evidence of a missing person, although that would be nice too. I'm looking for evidence of a crime. And I now believe in my heart, or I can't take it to the judge, that a crime has committed, and I'm going to find evidence somewhere in those vehicles or residence that's going to take me further where I can start to prove the crime and find these people.
Okay. So in that regard, you have a crime scene person with you, Dennis Williams?
She was my forensic evidence tech.
And you're going through the house and you're looking for potentially blood?
Yes.
Okay. You're looking for any signs of struggle?
Absolutely.
Any signs of forced entry?
Yes.
Okay. In your initial review, as you were going through the house, did you notice any of that?
No. Well, let me take that back on the back window.
Okay.
So that in the den of the residence, Michael had told me that in his statement to me on the 15th, I'm interviewing him in my car, and I said, how'd you get in the house? And he said, I met Chase on the 13th, and Chase had already been here. Chase had told me he had been here on the 9th, and Chase told me there was a back window open in the back of a secured backyard, and Michael, these are Michael's words, so I went to the backyard and I crawled in that unlocked, slightly ajar window, took the screen off, crawled in the window, and what I noticed as an investigator during the search warrant is there was a little bit of damage to the blinds, right there where he says I crawled in the window. I later asked him if he did the damage, and he didn't remember doing the damage. Not that it was a big aha moment, but he crawled in that window, and we have minor damage to blinds, and okay, that's what I got. So that's forced entry, but legitimate.
So this investigator talking about going to this alleged crime scene, and one of the things that many of the critics, especially of the prosecution case, have pointed out is the fact that there is not really a whole lot of, or any evidence, I should say, of foul play occurring at the home. For a family that was bludgeoned to death in a violent way, where is the evidence of the bloodstains? Take a listen, because that investigator was asked something like that during cross-examination.
To that point, you never changed your position that there was zero evidence of any foul play in the house. Is that correct? And that's what you briefed the FBI on.
I still profess that in my investigation, that's all I know. There was no evidence of foul play in the house.
Thank you.
Anything else? No, Your Honor. Thank you. I have a couple of things.
No evidence of foul play in the house. That coming from an investigator who examined the crime scene of where this brutal attack was supposed to have happened. LaDawn Jones, I want to bring you back in via Skype, criminal defense attorney. How damaging is that to the prosecution's case?
You know, if this theory is that they have presented, or they have witnesses that have put testimony forward that this incident occurred in any specific location, and you have a witness, a primary witness, like an investigator, saying, well, those dots don't quite connect. Again, like we've said previously, the prosecution has the responsibility of presenting a straightforward, direct explanation of what happened. Anything that undermines it, including your own investigator, especially your own investigator, ruins their case and creates reasonable doubt.
Right, and what I don't quite understand is if it's kind of murky as to where this crime was committed, why did the prosecution have to make a decision to so emphatically try to claim it happened at the house?
Well, in every criminal case, you have to prove jurisdiction, right? You have to prove that, particularly with the remains being found so far away, you have to prove that the crime, where the crime occurred, because you are accusing them of murder. If you were accusing them of tampering with evidence, then you would go to where the evidence was located. So in this particular case, if you don't know for certain, you have to kind of fake it till you make it. And the prosecution has to put up a case that makes it seem that they are dead set and certain about the jurisdiction of this crime.
All right, let's listen to some more testimony of a forensic evidence tech that talked about whether there was any evidence that anything had been cleaned up at the house. Take a listen.
You bumped something and transferred blood to it, correct?
Yes.
And the things in this garage, when you walked through, did it seem like everything was tight enough to where you would expect if a bloody large object was drugged through that it might have some transfer?
Objection calls for speculation. Sustained.
I'm getting the perspective of how tight the room is.
The objection sustained.
Is everything in this garage very close together?
It was crowded in there.
When you walked around, did you have to kind of turn to the side and move around things to get through?
I think sometimes I did.
Exhibit 82, nothing in anything in this photograph led you to do any kind of presumptive test?
No.
83, same question?
No.
Needs appear to be more paint cans inside the garage?
Yes.
And then this is over more towards that side door of the garage, looking back in towards the garage. Anything over there that you noticed and said, I need to do a presumptive test over here?
No.
You reviewed for 6 hours and 13 minutes, and then you reviewed with the prosecutor myself that shows that a scene of violence happened and it was cleaned up afterwards.
Objection calls for speculation. Overrules.
Well, I'd have to see the cleaning marks. So it would just depend. I don't know what the time period is here, whether things were clean and became dirty. I don't know whether they were always dirty. I don't know.
Great question. Do you see anything when you walk through the house or the photographs we showed that showed cleaning marks?
I don't know. I didn't notice.
I don't know, she says. She's not really giving a strong answer there. I don't think she performed very well on cross-examination. What do you think, LaDawn Jones?
Absolutely, I agree with you. She did not perform well. It is very obvious to a jury when a witness favors one side or the other. So you have all of this information that's direct and you can remember it off of an initial question when the state is asking questions, but then on cross-examination, suddenly your memory for things that sound pretty important to your expertise and your previous testimony, you don't remember. It comes off as false, and what it does is discount all of the testimony that you had before. A better answer would be, we weren't looking for that, or we did not see that as a part of our investigation, rather than, I don't remember.
Yeah, the fact how she answered that question being wishy-washy, especially as, this isn't just a citizen witness. This is actually someone who works for the government, who's been experienced as a witness before, has obviously taken the stand in other cases. To have such a wishy-washy answer, it doesn't come off well. Okay, LaDawn, stay with us. We have to take a quick break here on the Law and Crime Network, but when we come back, we're going to dig into Charles Merritt police interview 13 days after the crime.
Through box for the electrical on one of the waterfalls. But he had it at home. He had the drawings at home. So when he got there, he called me, and we went over that fairly quickly. But he was sitting, I know he was sitting at his desk at home, and I could hear the kids in the background, just like always. They were always screaming.
All right, so the defendant in this case, Charles Merritt, being interviewed by police, talking about the last meeting he had with the victim, Joseph McStay, at a Chick-fil-A, how it went on for quite a bit of time. And remember, that was the last time that anyone really saw Joseph McStay after he had met with the defendant, Charles Merritt. I want to bring in back LaDawn Jones, who's been with me for the last hour, and also introduce LaTonya Hines, who is a prosecutor, also joining me via Skype. Welcome to both of you. So glad you can join me here on the program for a very fascinating review of this case. Again, this case is on break for the day, and we'll return live on Monday. But let's talk about this police tape, because prosecutors are putting a lot of stock on what he did and did not say on the tape. We'll get into some of the more interesting details in a bit, but first, talk about this Chick-fil-A meeting. LaTonya, what do you make of that?
Well, it's important because one of the things that we have about a Chick-fil-A, it's public. A lot of other people would have possibly seen other people there, but it's the timeline. If we believe the timeline that this is the last time that they saw each other, it becomes very crucial. And supposedly they were there for two to 3 hours, so that's a really important timeline for the prosecution. And the fact that he is admitting in his interview that he did see him. Although he does later go on to say that he talked to him over the phone, it's important, this Chick-fil-A bit of information.
And what do you make of it, LaDawn?
I agree. LaTonya is absolutely right. You want to be able to establish a timeline as a defense attorney. You want to be able to establish that, listen, I had no reason to have any violent action against this person. I saw him. That would explain any fibers of mine that you may have seen near him. Yes, it can explain why we may have been in the same location around the same time. But outside of that, I have no direct connection with his murder. And so it also gives him some credibility because it's something that they can actually prove that occurred. He was at Chick-fil-A on that particular day.
But the defense is actually trying to use this to their advantage, because you'll remember the DNA was found in the car, and the defense is trying to say, well, they shook hands at the Chick-fil-A there, and that's perhaps why it ended up on the McStay's car.
Well, I mean,
I'm sorry, LaDawn, continue.
That's a very important part. You have to be able to explain away scientific evidence in particular to a jury. And remember, they're always instructed on reasonable doubt. And so if the only clear connection of DNA evidence is in the vehicle, then a clear explanation of how that could occur, it would help the defense out in a big way.
Yes, because they've said over and over again that the two of them were quite close business associates. So the fact that DNA was in the car is not necessarily that shocking and shouldn't, according to the defense, be used against Charles Merritt as evidence that he committed this crime. When we return, we're going to play more of this police interview tape, and there's something that Charles Merritt said that really got police suspicious. We'll bring that to you next. Following breaking news in the arrest of Roger Stone, a longtime friend and aide to President Donald Trump. He was arrested early this morning in his Fort Lauderdale, Florida home on 7 counts, including lying to investigators. Just a few minutes ago, he spoke out following his arrest. Take a listen to what he had to say.
The charges today relate in no way to Russian collusion, collaboration, or any other illegal act in connection with the 2016 campaign. I am falsely accused of making false statements during my testimony to the House Intelligence Committee. That is incorrect. Any error I made in my testimony would be both immaterial and without intent. I find it disturbing that the special counsel's office released a press release prior to informing my attorneys that I would be charged today. I will plead not guilty to these charges. I will defeat them in court. I believe this is a politically motivated investigation. I am troubled by the political motivations of the prosecutors. And as I have said previously, there is no circumstance whatsoever under which I will bear false witness against the president, nor will I make up lies to ease the pressure on my...
And just minutes after Roger Stone going into a federal court to face that 7-count federal indictment, he takes to the courthouse steps to release his statement saying that he is innocent of all that he has been charged with. Here's a shot of him arriving at the courthouse in a vehicle from earlier this morning. I want to bring in my guest, LaDawn Jones, criminal defense attorney, LaTanya Hines, a prosecutor. LaTanya, just weigh in on your reaction to what Roger Stone said following his arrest.
First of all, he shouldn't be saying anything. I mean, I've been a defense attorney before for a short period of time, but he shouldn't be saying anything. He should be quiet. This is part of the problem with a lot of what's been going on with this investigation. You've got 2 things going on. Besides WikiLeaks and the collusion with the Russians, you've got this issue that a lot of these figures are trying to do their trials within the media. And I think it also makes it very difficult for their own attorneys when they're actually having to do the case in the courtroom. So I think he should just be quiet. I think that you let this stuff play out and let your attorneys deal with it in the courtroom. And plus the idea that the special counsel's office had this right or should have informed his attorneys ahead of time. You don't do that. They don't need to do that if they're doing an investigation. They didn't owe him anything for that. I'll tell you one thing that he did say that I thought was, it's going to come back to possibly bite him, when he said that if I possibly said anything that was incorrect in my testimony, it was inadvertent. Well, incorrect is true or not true. Like either you told the truth or you didn't tell the truth or not, and that might come back.
So that's interesting for bringing up that point. So is this the type of crime where the intent, like in other words, if you said something accidentally that was untrue while you were testifying before Congress, that even though you didn't intentionally mean to do it, you could still be charged with a crime?
Well, I think it's probably what's more problematic is saying that if they have evidence to show that there's no way that you were incorrect, you knew what you were doing.
So he shouldn't have even admitted to the fact he might have been incorrect if you were his defense attorney advising him.
I think you just don't say anything. I think you let your attorneys go and speak for you and say that we will show this out in court and that we will let this play out in court. We have nothing to say at this point in time. It's disappointing that it came out this way and that our client had this happen to him in this manner, but we will find his vindication in court.
And LaDawn, I got to say, just from watching him during that press conference, it almost kind of seemed like he was enjoying all the spotlight there.
And are we surprised at all? Absolutely not. It seems like many of the characters that have been involved with this entire scandal have had the same circumstance. They like the attention. I am certain that Roger Stone's attorneys told them exactly what Attorney LaTanya said. Don't say anything, but if you're going to say something generic. Thank you for your support. We can't wait for this case to be resolved, and leave it at that. But of course, him coming out and saying it's par for the course, I will tell you, it made my day that there was someone out there able to chant back at him, lock him up.
And by the way, it was just announced that Roger Stone is going to be on Tucker Carlson on Fox News this evening as well. So that will certainly be interesting to watch. I can only imagine what will go down during that broadcast. So we have to shift gears now to this horrible murder case that we're following out of California, because we're in a crucial part of the case as jurors listen to the police interview tape. Just 13 days after the McStay family disappeared from their California home, Joseph McStay's business partner and now defendant in this case, Charles Merritt, was interviewed by police. And again, as I mentioned before, there was something he said that made investigators very suspicious that he was involved. Let's listen to that police interview tape.
Do you think, or have you ever thought, that Summer is a guy?
I tried not to think about that, actually. Mikey and his mom keep saying, things like that, but, I don't know of anybody that's hurt Joseph, or two little kids for that matter. So,
do you have any knowledge or information that indicates to you that it did?
No.
Okay. The reason I ask is because you have used the past tense about Joe a couple times. And you said Joe was. Typically people don't do that when people are alive. Any explanation as to why you may have done that?
No, not really. I just, no.
You understand what I'm asking?
Well, of course. Of course. I completely understand. But no, I've never really even thought of him as possibly being, well, I can't say I haven't thought of him as possibly being dead, if I have, but I don't like to think of it that way, of course. So, no.
It's interesting because, we deal with families and friends and people all the time. And oftentimes they'll notify them that their loved one is dead. They will still use the present tense because it really hasn't set in. And that's why I'm asking you to use the past tense a couple times, which is really unusual.
Yeah. I have no idea. I'm not sure what I use past tense in context with, but I have no idea why.
You said Joe was my best friend.
Oh. I did.
You did?
And, well, I don't know why.
Okay. Did you guys have a falling out at all?
Never.
Okay. So it wouldn't be like he was my best friend and now we're just...
No, absolutely not. Joseph is...
Okay, still your best friend.
Okay, so 13 days after the family disappeared, no one had mentioned that they might be dead. Charles Merritt is talking to police and starts using the past tense about the family. And you could hear he's specifically questioned by police. Why'd you do that? LaDawn Jones, you're with me via Skype. What do you make of his answer in particular to that question?
You know, it was a slip of the tongue, right? And he was caught by a very keen and observant law enforcement officer. And, you know, once that comes out and is played before the jury, it's very difficult to wind it back. There is no good answer for that.
You could tell he was kind of, couldn't you tell a little bit that he was caught off guard about that, trying to backpedal?
Absolutely. So you can see both in his words, the tone, his body language all indicated, whoops, I was caught.
LaTonya, that doesn't mean he's guilty, though, does it? Just because he said past tense?
No, it doesn't mean that he's guilty, but let me tell you, as a prosecutor, it is a major gift for your case because, you know what, even when someone passes away, let's say they passed away of natural causes, you normally will still sometimes use them in a present tense. But if somebody consciously killed someone and you know this person is dead, and it's not that they died because of some type of you know, when you have an emotional connection with somebody, you might still want to think of them here. But if you know you killed someone, you know that they're gone.
Yeah, it's almost like you can't get it out of your mind that these people aren't there anymore.
Correct.
If you're the family and you don't know, you're keeping up hope that they could still be alive, you're not going to immediately go to the past tense. But if you know in your mind what happened, it's hard to separate that and put on a different act when you're talking to police.
And I think that's what jurors, when they listen to things like that, they think like they would think if they were listening to this. They're going to be, oh, why would you say was unless you knew they were gone? And how would you know that they were gone but for the fact that you had some involvement in it? And it goes with the state's case.
All right, thank you. Okay, the case against Charles Merritt is on break today, but we will be back live in court on Monday around 12 p.m. East Coast time. We'll bring it to you live here on the Law&Crime Network. For now, we're going to switch gears and take you inside the Claudia Horrod case. We have to take a quick break, but when we return, that fascinating case. Okay, so if you think this prosecutor is passionate during the openings, you should see what happened during the closing arguments during this case. Things really got a bit out of control. But let's dial it back to the prosecution's openings while he discusses more specifically what Claudia is accused of doing.
We have this man preparing to end a marriage, to leave the house and let her live in the house after less than 2 years of marriage on that weekend. While he's preparing to leave her, she's preparing to kill him that weekend. She's actually on Saturday going to the Slug Master's shop in Braceville, which is not far from Newton Falls, and she had been there previously, looking for a weapon. She's looking for a weapon with hitting power. She's also looking for ammunition, and we will have witnesses from police to the forensic pathologist. She wanted bullets that would expand, hollow ones. So he's out flying, doing his job. He's got $100 down, the evidence will show. And on Saturday, she goes and purchases a Smith & Wesson .357, 5-shot. And Mr. Becker will introduce a witness.
Okay, so during the openings by the prosecution, he's really hammering home the point that Claudia went out and bought a weapon. I presume, I'm going to bring my guests in, my experts to answer this, but that's to show the premeditation factor of this crime.
That's correct. That's exactly why you're doing that, showing that this isn't something spontaneous. It's not that you're reacting to all of this abuse. This is something that you've thought about, and that not only did you think about it, you took steps to be able to implement it. That shows premeditation.
And there you can see we were just looking at the gun that they showed to the jurors and they brought out in court. How much do you think that played into the fact? Again, you know, we just got this guilty verdict in yesterday, so we're taking a deep dive into how the jurors got there. But that fact, do you think, LaDawn, that weighed in the jurors' mind?
Absolutely. Listen, jurors, when they are faced with competing facts and evidence, go to the credibility of the people who gave those facts and evidence. And if she looks uncredible and looks like she's trying to stretch her reasoning, she looks like a liar, and the jury's not going to believe her. I'm sure that played a very big part in determining her guilt or innocence.
All right, let's continue now to listen to the defense's openings. As I mentioned, they're trying to get her on a lesser offense, admitting she did it, but that this was not calculated. Let's listen.
And pulled the trigger, and the gun, because it was fixed in the block of wood, wouldn't recoil upward, causing her to miss her target. I told you what happened on the morning of the 12th already. So, we're back to the 12th. Mr. Herrig is dead. Mrs. Herrig is shot and killed him. You hear from her at that point, she attempts to kill herself, thinking she's got 2 bullets left in her gun, but she doesn't. You're going to see from the records and from her testimony that at that point she calls Brazil. Calls Brazil and talks to her family. You're going to hear from her the family talks her out of killing herself. And the family gives her the advice, she'll tell you, to leave Ohio. She'll tell you they told her Ohio has the death penalty. You need to get out of there. Came back here, sat down. You're going to hear, you're going to watch. She sat down with the detectives. You're going to watch. She spends a half an hour or so. You're going to see in the video telling them she really doesn't want to talk about what happened. She doesn't want to give them all the information because she doesn't want to hurt Carl's family. She doesn't want to impugn the dead man. Before finally she talks for about 3.5 hours. You're going to hear throughout that statement Marshal Bolton repeatedly say, well, yeah, that's exactly what you told us on the plane. And that's the evidence you're going to hear. As Miss Herrig told you herself, as she will say herself on the thing, Carl Herrig is dead because she shot him. And she shot him because at her moment of weakness, 30 days after she's attempted suicide, when she wants to have a conversation with him, he tells her, go ahead, kill yourself. Just do it in the basement so you don't get my stuff messy. Ladies and gentlemen, that's the evidence you hear. That's why the lie is so important in this case. You won't hear any evidence of premeditation, planning, or design.
Okay, so I'm not quite clear exactly why the defense was recounting all the details, which are quite incriminating for their client as part of some kind of defense strategy during the opening statements. We have to take a quick break, but when we return, we'll dive into that, whether that was effective. We'll be back to continue our look into this case. Stay with us. Okay, so that's the employee at the gun store talking about when Claudia Herrig bought that gun. And I want to talk specifically because this is actually a pretty important part of why the jurors ended up convicting her of aggravated murder. I want to bring in my panelists again, LaDawn Jones and LaTanya Hines. They join me via Skype. Why is that detail so important?
So it makes a humongous difference on how a jury receives the evidence. Do they believe what the defendant has to say? Is it credible that she could have obtained a firearm in this particular circumstance? And I'm sure LaTanya may have some more reasoning as well.
And the fact specifically that she had bought that gun with a laser sight for her gun. LaTanya, that raised suspicions, especially among the jurors when they were interviewed after they convicted her, one of the jurors anyway.
Right, exactly. I mean, why are you going to get a cite on something unless you definitely want to be able to use this for purposes of pinpointing something? And it's the practice. It makes you think that this is premeditated. You don't usually get a cite on a weapon that you're going to go and kill yourself with. That's not what happens. And I think what also comes into play is this. If you guys recall, we just listened to the defense attorney a little earlier do their opening, and they were talking about, she didn't plan this. She left all her clothes behind. So this wasn't a planned thing. But several days before, if it's not several days or a few weeks before, $10,000 was transferred to Brazil.
Mm-hmm.
Plus you got this gun. All those things start adding up. It makes you think, well, what were you planning for? You don't need clothes. You can get clothes in Brazil, but you may not be able to get money. And so why are you doing that?
And LaTonya, I think you make an excellent point. If you're going to use this gun to kill yourself, why would you need a laser pointer in order to do that? And the jurors, as I mentioned in a post-conviction interview with the media, one of the jurors mentioned that. Okay, we're going to take a quick break here on the Law and Crime Network. But when we return, you are not going to want to miss this, because Claudia Herrig takes the stand in her own defense. She breaks down on the stand talking about all the abuse she claims she faced at the hands of her husband, and some other details that I think you will find quite surprising. Stay with us here on Law and Crime Network.
Did this cause a lot of stress between you and Carl?
Very, very, very much so.
And what happened?
Well, when he realized that I'm really not going to have the abortion, he started torturing me psychologically, physically, finding ways to stress me out so I would have a natural abortion, a miscarriage. Sleep deprivation. He would make me run miles, and then he would leave me out in the middle of the woods in Newton Falls, dark, like 6 p.m., and then disappear. I would freak out and start running real fast because I was scared that he left me behind. So I started running. I was pregnant, and I guess that it wasn't good. It was early pregnancy. He would do that and he wanted me to get in real good shape. He made me to work out with weights, and he was like a personal trainer while I was pregnant. I guess all of this made me have the miscarriage.
Okay. So you had a miscarriage?
I did have a miscarriage, yes, in the middle of the night, and I woke him up and said, Carl, I'm feeling a lot of pain. I hadn't seen the blood. I'm having a lot of pain here, like I'm having my period. And then I sat in the bed, and then I looked down, and there was blood. I said, there was blood here. There was blood. I didn't have experience with it. There's blood. There was blood. It was the middle of the night. He said, okay, we'll go to the doctor in the morning. And we went to the...
Okay, we're going to continue playing some more of her testimony. Before we do, I want to bring in LaTonya Hines, who joins me from Atlanta, Georgia. She's a prosecutor there. She's been with me for the last hour or so. Claudia Herrig's testimony, I don't quite know what to make of it.
I don't know. I mean, it's a little bit gross, to be honest, but here's the reality. She had to take the stand. There's no way that you can go and say that you did something by mistake, or that there was even possibly some self-defense element, if you want to even call that, if you don't take the stand. And so she had to do that. Her testimony, I guess, is to try to show that she was in a controlling relationship with this person, and maybe she had some stresses that were coming from that. But it's just kind of disjointed. Here's the problem for Claudia. Outside of the fact that she killed her husband. She's not very, I don't want to say believable, she's not likable.
No,
she's a likable person.
I agree with. Yeah, she's
her.
not likable. And I gotta say, I don't believe a dang word coming out of her mouth as she's describing what happened. And what we've heard so far is not even the most important part of what she's
Correct.
being accused of. It's the lead up. So let's listen to a bit more of her testimony.
And so he fell on the floor at the bottom of the steps?
He did.
And then what did you do?
I want to say that I went down and shot him. Shot, no, I don't know. I didn't know if I hit him or not, but in my head, I shot 3 times, and I hit him 3 times, saving 2 bullets for myself. I didn't realize that I had shot 5 times, but I know for sure in my head that I shot and hit him 3 times.
So you're walking down the steps and you shot him?
The first one, I was on top of the stairs. And he died from this one, I know for sure. But in picking through my brain, I kind of see myself going down those steps and get to the bottom. And I believe the shot number 2 and 3, I was next to him downstairs.
Did you check to see if he was still alive?
I did. I checked his breathing. Not at that second. I checked when right after I killed him, I shot him. I went to the bedroom where I had the wood block, and I put the trigger to kill myself. Since I had already shot 5 times and I thought it was only 3, I put the trigger once. It was very, very difficult, but I did. My blood was hot, and I did pull that trigger. Nothing happened, and then I thought, no, I'll pull the trigger a second time. Nothing fired. It was, what the heck? What happened here? It was so difficult. So I said, you know what, maybe the bullets are bad or something happened to this guy, I don't know. I ran to the basement to put 5 new bullets in the gun. And at that point, I stopped and I realized on his body, I realized what I had done. And I said, let me see if he's still alive. I'm going to call 911. And I checked for his breathing and I checked his pulse. He was dead. He was dead. So I said, you know what? Now I gotta finish what I started. I ran and to pull the trigger the 3rd time, and my head set again on that little stool, and it was hard to pull the trigger. But that wasn't the reason. The reason why I thought about my family, I wanted to let them know what I did. I didn't want them to know that I did that through the newspaper. So I called them and I said, look, I did this. I lost my mind. I did this. I killed Carl. And I'm about to kill myself. I just want to say goodbye.
And you called 2 people.
I just want to say goodbye to you. I'm so sorry that I did that. That I let you down.
So one really weird thing about Claudia Herrick's testimony that you're just hearing right there is that she's crying, but I was like looking really, really, really close on the screen. I could not see any actual tears come out. LaTonya, what did you make of that story of what she says happened when she killed her husband?
Oh, and here's like the most interesting, bizarre part about it is when she's like, yeah, well, when I killed him, then I checked to see if he was breathing. Oh, I mean, I'm sorry, I shot him. It was like, well, what you really did is you made sure he was dead. That's probably more accurate about what you did.
Because she was trying to say that she was going to call 911 if he was still breathing.
Correct. But to me, it seemed more like you were trying to. What really happened is you made sure he was dead. And she's not believable, and she's not sympathetic. I mean, I think that's really one of the hardest parts. And I think even when you're a defense attorney, you really kind of. She did more harm to herself going on the stand, but that's one of those things that always happens when you have a defendant who's on trial when they go on the stand. She did more harm to herself, but she had to take the stand And unfortunately, it was kind of like Russian roulette for her.
I'm fascinated by watching her on the stand. I just can't believe some of the things that are coming out of her mouth, specifically talking about how she didn't realize she had shot 5 times. She was planning only to shoot 3 times, and then all of a sudden, you know, there she is with the gun trying to commit suicide, and oh dear, she couldn't do it because she had shot 5 times, her husband.
Correct. And I think what also is kind of happening here is that she is trying to throw in this kind of like, maybe I'm like a battered wife syndrome, and this is like, you know, all these things in at the same time to kind of justify why she did this and how she couldn't understand what she was doing. Like, you know, this happened in the heat of the moment. She didn't really understand what she was doing. Kind of almost like a back end, like a brief insanity defense or whatever. But she's just trying to do whatever she can to explain away something that's very hard to explain away. 5 shots. Like,
and then you have all these sexual elements that she tries to bring up as well. Okay, so we got to take a quick break, but I got to tell you, you're going to want to stick around, because when we return, Claudia Herrig is going to be cross-examined by the prosecutors about her story. You're going to want to see this. Stay with us here on Law and Crime.